Hi, I'm Sarah Maffey-Holland, and I'm a licensed New Hampshire real estate agent, and this is Man versus Land, a segment intended to educate the public on various home and landowner topics, as discussed with guests who happen to be experts in those fields. My guest today is Mark H. Lamper, and he's a New Hampshire real estate attorney, and he's also the state manager for Priority Title Services. Before we begin, just want to share with you a little disclaimer that the show is for educational purposes only. It does not constitute any legal or real estate advice. We're always happy to field any questions that you have, but unless you enter into a written agreement, then we are not acting on your behalf and nothing is confidential. All right, so today's topic, Mark, we're going to touch base on some landowner issues, particularly home ownership, and what that looks like to the public. And any topics that we need to discuss at length that we don't discuss today will be in further segments. So, Mark,
sounds great.
Welcome. Thanks for joining me.
Thank you very much.
So to start off, what does home ownership look like? What are the types of ownership that someone could have, whether it's a house or a piece of land or a condo or whatnot?
Right. The typical home ownership is single-family homes. So someone will have a standalone home, which traditional home we might have grown up in, or it could be a condominium. It can be a standalone condominium, or it can be part of a large complex. It can be a vacation home, like up in Lincoln, New Hampshire, or it can be down in Nashua. There are also, people can just have land and then for someday hope to develop or build. So there's all different myriad types of ways that they can own real estate. And they can hold it differently too, where you might own a home just individually yourself, or you and I might be able to own something together as joint tenants with rights of survivorship, meaning when one of us dies, the other one automatically becomes the owner.
Okay.
Or tenants in common, where one of us should pass away, your share, your undivided interest, would pass to your heirs, which may or may not be me.
Okay.
You can also hold property as a revocable trust. A lot of people do that for estate planning,
Okay.
and some people for investment properties hold them in corporations or LLCs.
Okay. And with the revocable trust, there's an irrevocable trust, right? What is
Right.
the difference there?
Typically, the revocable trust, inter vivos trust, is for estate planning, and it's a probate avoidance. So you fund your trust, meaning you transfer your property into the revocable trust. Incredibly easy to do. You don't need to be a millionaire. You don't need to have a trust fund. And what you do is when you pass away, your trust still exists. The home is owned by the trust, so whomever you named as a successor trustee then disposes of the property, meaning it passes it to your heirs.
Now, talk about the probate system and how that works, and what best way to avoid that for your heirs.
Right. Well, the best way to avoid probate is, one, you need to have a will. If you don't have a will, the state has written a will for you. And when you pass away without a will, that's called intestacy. And you may have a second marriage, you may have children who have moved on that you don't have a relationship with, and those people can still take. So the best way to avoid any kind of probate is to have a revocable trust. When you get your assets into some kind of vehicle that passes outside of probate, and it's really not as complicated as a lot of people think, then what you've done is kind of, in effect, prepay for a very small amount for what someone would have to pay down the road for probate. When you have a revocable trust, people can pass property on right after your death without court consent, as opposed to paying thousands of dollars and waiting 18 months to 3 years for a complicated probate process.
Now, are you able to put a property into a trust if you have it financed and a mortgage on it?
You can, actually. Even if you read your mortgage, which I've read a couple mortgages in my day, as I imagine you have, the mortgage does say you can't transfer away ownership of the property. However, there's a federal law that says you can transfer property into a revocable trust as long as the parties are the same. So if you and I owned real estate together, and you and I formed a revocable trust, if you and I as owners and the borrowers, the mortgagors, transfer the property to a trust where you and I were the trustees, that's completely kosher and we're allowed to do that. So even if it's finance, you don't need any bank permission to do so. Federal law allows you to do it.
Okay, great. And the transfer of ownership, how does that occur?
You transfer of ownership, except in the case of probate where you die, and then afterwards is typically done by deed. And there are three main types of deeds, two primarily, but there's three that get used commonly. There's a warranty deed. Warranty deed means that you warrant the title to the property, and you make could I name all six of them off the top of my head? No. But you have 6 promises that you make in a warranty deed. So you're saying you have good title, you'll defend the title against anyone else if they say that they have any interest in the property. So you've made a very, 6 important promises in a warranty deed. And then the rest of the property is just described in the deed, what's being conveyed. A quitclaim deed is what is used, and all that says is, when I transfer to you, Sarah, I'm giving you everything I have. Now that might mean I don't have anything,
Right.
but it's a disclaimer of any warranties, any promises that are contained in it. It's not used very often. It's quite often used just between spouses, adding or subtracting each other from title. And the warranty deed in New Hampshire is the most common way to pass real estate during your life.
Okay. And you had mentioned the word title. What does title mean?
Title, it's one of those words that means lots of different things. Just like escrow, there's all these other words in the world that we live in. So if someone has title, it indicates your ownership or your rights in real estate. So if you say, I have title to my house, I live down in Concord, I would say that I am the owner of that property, so I have legal title. I might share that title with someone else. I might have title to that property as trustee of a revocable trust, but in the common vernacular, it means that you own or have some ownership interest in that property.
So with title and deeds and mortgages, is all of this public information that anyone can find?
It is, and it's interesting because I was just talking about that today with someone, telling them how much they knew. And they said, what do you mean? So absolutely everything recorded in the registry, whether you decide to go look or you know it or not, you're imputed with that knowledge. It's called constructive notice. So anything that's recorded in the registry, deeds, mortgages, liens, attachments, anything that anyone finds of import to record, because it's available as public knowledge, you are, and you can conduct your own due diligence to discern that information, whether or not you do that or do it properly so you actually see what information's there, you don't miss anything, you're considered to have constructive notice. So you can't say, I didn't know.
Now, what about maybe somebody passing along a little handwritten note to their daughter, giving them rights to a property or whatnot? Does that have to be recorded to be legal?
Well, the interesting thing about that is, let's say that they have something a little more formal than what you mentioned, but so it does convey some right in property. Mm-hmm. That is effective. Any kind of conveyance is effective if there is the intent to grant. So the grantor is the person who grants whatever interest in real estate. If there's delivery of that and acceptance. So if we handwrote something here and it had enough information on it to describe the property, describe the parties, and I give it to you and you say, well, thank you, Mark, that is actually all the requirements you need to be an effective transfer. However, and this is where it gets confusing for a lot of folks, unless it's recorded in the registry, so everyone has actual or constructive notice, it's not effective as to third parties. So if I did that and I gave that deed to you, and then I gave it to someone else, because I'm just not a good guy and I deed the property to someone else, they go to the registry and they record that. So first in time, first in line. First one of public record would have priority. Even I might have given that to you a year before, then I gave it to someone else. So it's an effective transfer, but not as to third parties.
Okay.
So you don't do that. If you convey any interest in real estate, it's a priority to see an attorney or at least make sure that it gets recorded in the registry.
Okay. Title insurance is another big topic that goes along with title. What does that mean, and how is that important?
Yeah, title insurance came about, and I can't say how long, it's been 20 or 30 years. It's taken the place of nice marketable title. Marketable title means if you pass on title, so if I was going to transfer a property to you, there are no prior owners that have any interest in the property. All mortgages are gone. Everything's nice and clean as a whistle. If I had a mortgage, there's a discharge. If I had a tax lien, there's a redemption, and everything smells and looks pretty. However, there's property changes hands so often, and there's so many hands in the in the pot there, that it quite often things get missed. There was an improper discharge mortgage, so it still looks like there's something on title. Title insurance came about because insurance companies found a market to say, well, there's an issue, but we are so comfortable that the issue is minor that we are going to allow you to still have your closing. You pay us a premium for title insurance, and should that issue ever bubble to the surface someday, we'll take care of it. Title insurance is an indemnification contract. It means if you have a loss, they will cover you for that loss. And they do that by writing checks, or they take things to court to settle matters.
Now, what is the time period that title insurance covers?
Now, what the title insurance does is, let's say that you buy property today. We're talking about owner's title insurance, and you purchase an owner's title insurance policy. You are covered for any matters that predate that policy, and it protects you your entire ownership of the property, and even after your ownership. So let's say that you buy that policy today, and in 3 years you find out that 30 years ago someone was not listed in a probate, and they actually have an interest in that property. They were not listed because they moved away, the other siblings said heck with that person, and they weren't part of the probate process. They're still entitled to a portion or some percentage interest of that land. Well, that happened way before your ownership. That would be something that would be a covered matter that the title insurance company would litigate to make it go away, or write checks to someone to make it go away. It then covers you throughout your ownership of the property, should any of those things arise. And then even after your ownership of the property, you still have that protection for anything that might have arisen. Now, if you affect your title and you decide to convey an interest and not record it in the registry, or you change your boundaries, or you do something that's not kosher, you won't be covered for your own mistakes, but it covers you for before and after your ownership. And it's really pennies on the dollar. It's
Right.
like $2 per thousand of the purchase price. It's
Right.
a one-time fee.
Great. So that makes a lot of sense for everybody to have title insurance. Now, if you didn't purchase title insurance, if you bought your house, 30 years ago,
Right.
can you still purchase title insurance now?
Yeah, you absolutely can. The only time that the title insurance companies are a suspect is if you purchase your home, decline title insurance, and then a couple of years later you then try to purchase title insurance. So their first question will be, why? Why didn't you get it then? But more importantly, why do you need it now?
Right.
So it might be slightly more expensive to purchase it afterwards, only because they will require a full title search of the property, a new and unique title search, as opposed to the one that occurred when they bought the property, to make sure that nothing has happened. That all of a sudden they've discovered, oh, there was an issue, and I really wish I had bought that. So now if I buy it after the fact, no one they'll be none the wiser. So the insurance company won't willingly go into a claim where they're going to take a $300 premium and pay a $30,000 claim. So it's a little harder to get, but you can absolutely do it.
Right, and it's a good product to have. The insurance is very easy to get. It's very simple, and if you have an issue, then you still go to work every day, and you have somebody battling it out for you in the background, which is kind of nice.
And I would not wish it upon maybe my worst enemy, but my worst enemy to not purchase owner's title insurance. I say it's a no-brainer. It would cost money, and as the closing agent, I make money from it. So not to talk out both sides of my mouth. Yes, it's a profit instrument for us, but literally I've seen, and I've done this for 21 years, just hundreds of times where title insurance has allowed someone to purchase a property that they normally wouldn't have been because there's some issue. And it has helped people sell for that same reason, and has saved people's ownership in the property, because they spent, you could spend $2,000 if you bought $1 million house, or if you buy a $50,000 house, you're going to pay $250. Right. It's quite, there's the myriad of how much you can pay, but the one-time fee and the protection you get, and I say in a nice way, is a no-brainer, just because I've seen the horror shows of people who don't purchase title insurance.
Now, are all properties eligible for title insurance?
Not all of them. Some manufactured housing, mobile home trailers, depending on whatever term you use, they might not be. Some property on leased land might not be. There are some tax sale properties where the town has taken a property back because the individuals didn't pay their town property taxes. Then the town will sell that property to another party, trying to move it on, recoup their money. Those are very hard to insure. Historically, towns have not done a very good job of giving notice to the appropriate parties, so the title insurance companies are very, very leery. And lucky for me, I have 6 of those going on right now. So I know what a headache that there are. And there are some times that the title insurance company, just the title will be so poor that they say, no, we can't underwrite this. I mean, clearly if you went back and whatever the issue was, the old mortgage that wasn't paid off, finding someone who didn't release homestead, some other issue, then the title insurance company then will get to a level of acceptable risk. But it's possible to have that bad a title that no one will undertake that risk.
Interesting. Okay. Now, talk about the construction of a deed. What type of information goes in that people should be aware of?
The closing attorney will have 90% of that. But what we need is what type of deed, whether it be warranty or quitclaim, and your purchase and sale agreement is going to tell us that. And so when your real estate agent helps their buyer, their seller, negotiate a contract, it's going to tell us. So we know what we're drafting. For the most part, all we need is who the parties are. Who is the seller? Are they married? So these are the current owners of the property. That can also be discerned from a title search. Whatever their proper mailing address is, which is required by statute. The buyers, quite often the purchase and sale might say Mr. is buying, but it's actually Mr. and Mrs. that are buying, or they might be buying as a revocable trust. So you need to know the full name and address of the buyer, the full name and address of the seller, all their marital statuses. And that's really important because let's say that you and that I owned property, but we were married. Because of homestead rights in New Hampshire, I can't sell the property without you joining in that conveyance. If it's our primary residence and we are married, then you have what are called homestead rights in the property. They historically come from being a creditor protection. So if I ran off with someone else, spent all the money, you're home with the kids, I died, you wouldn't get thrown out of the house by the creditors. That right's been diminished quite a bit over the years because of advent of different, secured products. But still, nonetheless, it's you have to make sure you capture everyone's interest. So if we're married, I'm on title. You still have to join in that conveyance and can say no to that conveyance.
Right.
So that's why we need to know who the parties are and their marital status. If we were father and daughter, and you were married, well, your husband would have to sign if it was your primary residence. So we just need to know who the parties are. From there, we do the rest with the title search. We take the legal description of the property. It could be very long, very complicated, meets, bounds, degrees, inches, or we can say to an old birch tree that doesn't exist anymore,
Right.
to a stone wall that may or may not be there. Or we can just refer to a plan that's recorded in the Registry of Deeds. So it's like sands in the hourglass. There are that many different legal descriptions for deeds.
Right. Now, what about easements and encroachments with respect to a deed? What needs to be included?
Now, as far as easements, technically, if there's an easement already represented on title, best practice, it really, really should be in that deed. Because when you look at a legal description, it says, in theory, you could be able to draw out, well, this is what my land looks like, with some mild certainty. Real estate is uncertain by nature. However, if that property is subject to an easement, meaning someone gets to drive across your property to get to their property, that's because the driveway runs across, or they're able to walk across your property to get to some public body of water. That should be listed out in the deed, so the buyer can look at the deed and decide if this is something that they want to accept. Also, a deed should say, sometimes if that's subject to, it might be together with. It might describe some right that goes with that property. So you can draw out the property, but maybe I have the property that allows me to drive over someone else's yard. So best practice, it absolutely needs to be in the deed. However, remember that constructive notice I mentioned, if for some reason it is left out of a deed because of poor drafting, is not severed from that. An easement will run with the property forever, whether or not it's listed in the current deed that you have, because once it's in the registry, it's in the registry. But it's poor drafting and it's poor practice not to have it always listed, because you want to know what you're buying. You need to disclose what you're selling. Encroachments, now those won't show up anywhere. Those are unfortunately discovered by lay of the land. You might go to sell your property and find out when your contractor puts your beautiful deck that you get to enjoy river views and enjoy cocktails at night is 12 feet from the property line instead of 15 feet from the property line.
Right.
So therefore, you don't necessarily have an issue with your neighbor you get along well with, but you can have an issue with the town that says you are in violation of setback and zoning requirements and because you are encroaching upon someone else's land. The biggest issue besides having an issue with the town is if you have an encroachment, that makes that property not marketable to lenders. They won't lend where they walk into something knowing that there's a title issue or a zoning violation. So that can make it you have inability to refinance your home or to purchase that home if you're the buyer and you're going to use mortgage financing.
So with that example that your deck is closer to the property line than what it's supposed to be based on zoning regulations, how can you remedy that?
You have to get permission from the town. That's the long and the short of it is. And there's two different ways to do it. One is to get a variance. And a variance quite means vary from what the rule is. The rule says you must be 15 feet away. You're 12 feet. You go to the town. It's a process through the zoning and planning, zoning board, whatever it's called, zoning board of adjustment, depending on what the town it is. And you literally ask them permission for this to be okay. The answer can be no.
Right.
And so it's a necessary step depending on what you're doing. If you're there for the next 30 years and only you know about it, then necessarily you wouldn't raise that red flag. With the zoning variance, you need to give notice to all the different abutters too.
Right.
So that neighbor who you are 3 feet too close to, thus the encroachment, can have umbrage with it and say, no, that deck's awful and it's 3 feet too close and I want it gone. And then it's up to the town to give you permission or not. And the other option which is easier, is called a equitable waiver. So, you ask the town for the same permission, but you have to be an innocent party. Like you bought the house that had the deck too close. Your contractor made some mistake despite plans you gave them. You're not the ones who went out and decided to have it built exactly like that, and then so it's your fault. Your fault, variance. You can prove that you are an innocent party. Then you have a much better chance via an equitable waiver, which is much easier to get from the town. Long story short, the town has to say okay.
Gotcha. Now, speaking of towns, taxes. Everybody gets a tax bill, whether they get it once a year, twice a year, quarterly, whenever.
Right.
How is that billed from, I mean, you deal with that all the time when you're dealing with prorations for closings.
I deal with it all the time, and it's one of the things that we are most scolded about because people don't understand, even if they've lived in New Hampshire their whole life, what the tax year is. 98% of the towns in New Hampshire have tax bills twice a year. But New Hampshire has a fiscal year of April 1 through March 31st of the next year. So people feel when they get their tax bill in July, like, oh, well, it's half through the year. December is the other half, so I pay it every 6 months.
Right.
But that's not how they bill. And so this is something that's very complicated when we buy and sell real estate. The tax bill might come out in July, but the tax year starts April 1. So your July bill is April, May, June tax bill, July, August, September. So that bill that comes out in July is actually 3 months in arrears, 3 months in advance. Likewise, if it's a twice a year town, your December bill runs from the period of October 1 through March 31st of the next year. So depending on when you buy and sell real estate, sometimes the sellers have already paid their taxes, so therefore the buyer needs to reimburse them when they buy the property. Because if the sellers don't live there anymore, but they've already paid the taxes, they need to be paid back for that.
Right.
Now, in some cases, if we're in those kind of 3 months in arrears, the seller actually needs to give the buyer money because the seller's been there before the tax bill came out, but the tax bill is accruing during that 3-month period. So that's up for us to figure out. But 6 months out of the year, sellers give buyers money because the taxes are accruing but not yet due. 6 months out of the year, buyers give seller money because sellers have already paid their taxes and they need to get reimbursed for that.
Now the tax rates are or the tax amount that you pay every year is based on your assessment value of your home, which is
Right.
what the town does, and then the set tax rate for that year. So 2015 would have its own set tax rate. Now, how does that come into play? So when I look at my assessment and it says that, you know, my property value is this and this is my tax bill for the year. If I'm in between tax years, so I'm not paying that total amount for 2015, I'm actually paying half of 2015 and
Right.
half of 2016.
And there is a big element of guesstimate to it exactly
Okay.
when you have that situation. So April 1 is the beginning of the tax year, and that's when they'll set the value of the property. But just as you were alluding to, your July bill is 1/2 of the previous year's taxes. So if your taxes for the 2015, 2016, or 2014, 2015 year were $3,000, for the 16, 17 year, your July bill is going to be half that. It's
Right.
really easy. They just pick half that, so it's going to be $1,500, and you can count on that.
Right.
However, let's just say you had a reassessment, so that new value or that new tax rate, because they might do different dollars per thousand,
Right.
as set on April 1, you're going to feel the pinch in December, because
Right.
that's when that's the final tax bill. So any adjustments, up or down, up, are when for that pinch that you feel on April 1, when they've changed the value, it's December that final tax bill happens. And it's hard for buyers and sellers because you have to guess. When those tax bills aren't out yet, you can only use last year's numbers. And if it did change dramatically and your taxes are $1,000 more in December than you thought, sometimes buyers and sellers get cranky because they paid too much or not enough.
Right, and not even buyers and sellers, just homeowners in general.
Yeah, absolutely. Yeah, if you can find, if you're escrowing your taxes, meaning that you pay them as part of your mortgage payment every single month to the bank, and you have just enough money there, you're paying that every month, and then all of a sudden your tax bill goes up by $1,000, the bank mails you a letter
Right.
and says, "Hi, you don't have enough money in your escrow account. Please give us this money now of $1,000, or give us $50 more a month for the next 12 months," something along those lines.
Wow. So along with taxes, which we'll probably get into this topic in another segment, is the assessment process and how towns reevaluate property value, and then they apply the tax rate to it. Now, the tax rate has a valuation to it, a valuation equalization ratio, I guess
Right.
is what I'm saying. So it's not necessarily, you're not getting taxed on necessarily 100% of your assessed value. It could be less than that or it could be more than that,
Right.
based on what the town needs, correct?
Correct.
Okay, great. So I guess this is all for now. We're running out of time. So thanks for hanging out with us, Mark, and answering some questions, and hopefully you'll come back.
I absolutely will. Thanks for inviting me. I
All
appreciate
right,
it.
thank you.